Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode 95 of our podcast. I'm very excited. I'm only 5 episodes away from episode 100, which is only a few weeks away. Today, as you know, I've been talking about litigation for quite a bit, and I'm a business litigator here in South Florida. Now I'm celebrating my 20th year of practice. Actually, was in October of last year. So I'm very excited about that. So today I want to talk about a topic, and the topic is, how do I prepare for a breach of contract trial? It could be a business litigation trial, could be any type of trial. But once you decide to go to trial, what it means is that all efforts to try to settle the case have failed. Whether it's attorney negotiation, that goes throughout the process of litigation, mediation, which I've spoken before, that sometimes occurs twice. Sometimes occurs at the beginning of the case to see if the case can be resolved at that moment or at that stage to avoid future legal expenses, or perhaps close to the end of the case to see if the matter can be resolved and avoid the uncertainty and the expense and the stress of a trial. So when that has failed, then there's no other option. The other option is to go to trial, and whether it's a jury trial or a bench trial. Let me explain the difference between those two. Jury trial is what it means, the ones you see on TV, that you select a jury, and then you present the information, you present the evidence to the jury, and then the judge is there to be the umpire, so to speak, and basically make sure everybody follows the rules and, rule no objections, sustain objections. But the fact finder in this case for a jury trial is the jury. There's also something called a bench trial. In a bench trial, the judge is the fact finder, but it's also the ultimate arbiter as well. So in this case, you present the evidence to the judge, and then the judge decides, based on the facts and the evidence, who's liable, who's not. And the judge will also decide in this case what type of damages, if any, the aggrieved party would receive. And in fact, in the next 2 weeks, I have 2 bench trials back-to-back in consecutive weeks. So I'm going to be busy next week, and also that's the reason I decided to prepare this podcast. It's kind of topical, and it's top of mind for me. So it's also a good review for me as well. So say you're going to trial and you have exhausted all the remedies that you have attempted to settle and just didn't work out. Trial is the inevitability, and you go with it. Go with that. Having said that, there's nothing preventing a party from settling just before you go to trial, or during trial. The parties can still negotiate and try to settle the case. That's just because you go to trial does not mean that you're prevented from settling the case based on how things are going in the case. Circumstances change. Settlements are always an option until the time that verdict is rendered. And even after the verdict is rendered, the party can still negotiate and settle the case in different terms. But there's nothing preventing the parties from trying to settle the case at any point of the litigation. So, tip number 1, I think understanding your case and your role is very important. And this is very helpful for you. And I tell my clients something. I tell them that you know the facts better than me, because you live those facts. You live what happened that led to this litigation. I know the law. I know what to apply the facts to the law and argue. So the attorney relies upon you as the client to really provide those facts and provide those nuances, those details that sometimes the attorney may miss. We get the information from you as you provide it to us. We try to take notes and try to remember as much as we can. We try to piece together the evidence based on the email communication that you exchange with the other side, based on the documents that we subpoena from witnesses, based on the testimony of witnesses. So we put this story together based on all this information that we receive that after the fact, after obviously the events occurred. But there might be things that the documents themselves will not reveal. The context of the communication will come from you because you were part of that communication. And we can read text messages and try to create context, but the reality is we will not be able to as well as you because you lived it. So understanding the case and understanding your role is very important, and also explaining really what happened to the attorney as best as you can, and making sure the attorney understands your position and from your perspective of what happened. Understanding what, if you're the plaintiff, understanding what you need to prove to prevail in the case. What elements or what evidence you have to prove in order to prevail in the case. In a breach of contract case, since we're talking about that, 8, was there a contract? Obviously, by the time that you are going into trial, most likely there was one, otherwise that would have been dismissed through summary judgment or would have been disposed already in different other procedural motions. Was there a breach? Who breached the contract? When was it breached? What are the damages? Understand from your attorney, this is what I'm trying to prove. If you're the defendant, then understand what the other side has to prove in order to prevail against you. What damages they're seeking. So understanding that goes into what evidence will be provided and what you have to refute in order to prevail in your case. And understanding kind of a roadmap with a strategy with your attorney is very important. The attorney has a game plan. At least they should have a game plan and how he or she is going to arrive at that verdict. There are no guarantees, but having a game plan is very important, and the game plan can change based on new circumstances that will happen at trial. A trial is a live event. Okay? It might be a circumstance that the other side volunteers something that you were not planning on, so you take that to your advantage. It might be something that maybe you as the witness, and we'll talk about your testimony in a second, you may not have a good day that day. You wake up late, you wake up tired, and you may say something that might not be good to your case. So the attorney has to make adjustments to the strategy and tactics based on what happens at a trial in a moment's notice. But going with a game plan is very important. Understanding the timeline of events is also very important. You need to have the timeline clearly in your mind and nearly memorized to the best that you can. Because the timelines tell the story. We know there was a contract. The two parties agreed at some point to do something. And throughout the relationship, somebody breached the contract. Somebody did not do what he or she was supposed to do, and somebody got damaged. When did it happen? How did it happen? And what occurred during that time is important to understand that. It's important to know and discuss with your attorney during trial preparation what documents your attorney is planning to use to promote your case or to prosecute your case or to defend your case. And especially during your direct examination, understanding what do the documents mean and why they're being used. And I'll just give you an example. Your attorney says, Mr. Smith, have you seen this document before? And you are his client. You don't want to say, no, I've never seen it before. It's the first time. And of course, I'm being facetious, but, I just want to give you that example. You want to make sure that you don't have surprises at your trial, especially during your direct examination and also during cross-examination as well. Your attorney needs to prepare you for any possible, have to anticipate the type of cross-examination that you'll receive. So that kind of gives me into preparing for a testimony. It's important to you to be consistent. If you're going to trial, it is likely that a deposition was taken from you and that you gave testimony under oath, deposition. And I've had several podcasts that have discussed deposition, how to prepare for them. So if you listen to me before, you already know what a deposition is. Listening to me for the first time, deposition is like a court proceeding, but it's scheduled. It could be at an attorney's office, or could be done via Zoom or video conference, and you answer questions under oath. The objective of the deposition is to gather evidence to be used against you at trial or through summary judgment. But it's usually done by the other side, by the plaintiff, by the opposing counsel, and the objective is to really get information and utilize that evidence against you. So I'll talk about consistency. So we also use those depositions for impeachment. What does that mean? So you're at trial, and they are going to ask you questions. They're not going to go through a deposition, but they're going to ask you questions about the case. They're going to ask you, questions, most likely be a cross-examination if you're the opposing side. And they're going to challenge you and challenge your credibility. The way to challenge your credibility is to find inconsistency in your testimony that you give live in front of the court versus what you said in your deposition. So that's one way to attack your credibility. So it's important before your trial to read your deposition transcript. And if there's anything that you said at your deposition that has changed or you need to clarify, let your attorney know before trial. Because it's possible that you might have said something in your deposition that could be misconstrued, or you remember it in a different way. And when you're going to give your live testimony, it might be a slightly different answer. If that is the case, just let your attorney know, listen, just to let you know, my depo answered this following, and it might not be exactly correct. So your attorney has the opportunity to what we call rehabilitate you, and during his or cross-examination, have you address that issue. But if it's something like that, let your attorney know, and your attorney will develop a strategy on how to handle that. But it's important to have the least amount of surprises at trial to the extent that you can. It's important to know that your testimony is based on your personal knowledge, not on the knowledge of others. And let me explain. Sometimes people answer the question, yeah, you know what, I heard from Johnny that, the opposing party was going to breach the contract. Well, that's inadmissible hearsay. So you can only do that if it's something that the opposing party said versus what somebody else said that is not part of the litigation. Now, you can say the opposing party told me he was not going to fulfill the contract. He was not going to pay my bill. He was going to provide the services. That is admissible because it's a statement against interest. So understanding what the testimony is going to be, that is based on your personal knowledge, not in the knowledge of others or third parties that are not related to a litigation, because it's not going to be admitted, and it's going to be objected through as an inadmissible hearsay, and it's going to be sustained by the court. So understanding that is very important. It's important that you answer the question that is asked and listen to the questions. Don't volunteer information that has not been asked. It's important for you to listen carefully, and it's the attorney's responsibility to listen to information, to ask the question, and for you to answer the question truthfully and under oath. And there might be sometimes a situation where you do not remember the answer. You're nervous. It's a stressful process going to trial, and it's not something that you do every day. And you're put on the witness stand, swearing under oath on the penalty of perjury to answer the truth. So that's a stressful process. So it will not be surprised that you might not remember everything that you're asked at the moment. But also it might be a situation where a document may refresh your recollection. It might be a financial statement, it might be an email, and you can say, I don't remember. If you do not remember the answers to the question, say, I do not remember at this point. You can say there's an email, which if I review it, I refresh my recollection. And the attorney can provide it to you or not. But don't guess when you're answering the questions of your during direct or cross-examination, and don't try to help the other side. Just listen to the question, answer it, and if they do not ask the question, you don't have to answer it. And of course, I remember I mentioned the issue of consistency, and because any type of inconsistency from your deposition to your live testimony very likely will be held against you, used against you, and are going to be used for the purposes of impeachment. And when I mention impeachment, it's basically to challenge your credibility as to the statement that you made in your deposition or your interrogatory answers or any type of sworn statement and to your live testimony. Let's talk about cross-examination. Cross-examination will be when the opposing counsel is going to ask questions to you under oath after your attorney asks your direct examination questions. So your attorney is going to ask direct examination questions are going to be, most likely you will know those questions and you will know the answers. And very likely you're going to be softball questions that you will know because it's to present your case. It'll be in a methodical fashion to present the documents, present the evidence, present the contract, to explain from your perspective what occurred that led to that breach or what occurred that you believe that you did not breach the contract. But your attorney is going to lay out the foundation for your defense through your direct examination. Now, the opposing side will have the opportunity to cross-examine you. It's not going to be fun. But what I can advise you here is to remain calm and poised and professional. Your behavior is very important. Your demeanor is very important at trial because you're being seen and judged by the jury, but also by the judge as well, if it's a bench trial. But you're being judged. It's a trial. But also not by what you say, but how you say it and the demeanor that you have. The cross-examination, depending on the attorney, sometimes can be combative, can be a little bit aggressive, confrontational, will not be disrespectful. I don't think the judge will allow that. But the objective is to challenge you regarding your statements. What is important here is to listen to the cross-examination and to answer your questions at your own pace. But also, if you do not understand a question that is asked of you, then don't just ask for clarification to the question. Ask to review the documents that will shed some light to the answer. But it's important for you to listen, remain calm, and answer the question because the purpose of cross-examination is to completely defeat whatever your attorney did during the direct examination. Another thing that I like to share with you is that don't argue with opposing counsel. Don't get into an argument with opposing counsel as to the question. Yes, you might take it personal. Okay. The opposing counsel is not there for you to like him or her. They're there to do the job for their client. So you might not like the opposing counsel. But at the same time, we got to remain professional and calm and just answer the questions. Just stick to the facts. Again, if you do not understand a question, ask the attorney to rephrase the question or clarify it. Nothing wrong with that. But arguing with opposing counsel is not going to be helpful, and much less arguing with the judge. So another thing that I wanted to share with you here during the cross-examination is that if they ask you a question and you said, I do not want to answer the question, that could bring a set of issues. If there's a specific topic or question that your attorney anticipates that will be asked, and you do not want to talk about that subject matter, it is important to let your attorney know in advance. Your attorney will evaluate that particular topic or statement that you do not want to discuss, and then advise you whether or not you have to address it, you have to talk about it because it's relevant to the case and is material to the claims or defenses, or we also have something called motions in limine, which allow us to send a motion to the court to exclude or prevent the other side from discussing certain aspects of the potential testimony. And then the court will decide whether or not they will grant the motion in limine or deny it. But it is not a good idea at the moment of trial, when you're in live testimony, to refuse to answer a question. Because what happened is this. The attorney did not know about it. The attorney is going to be a bit blindsided, number one, which is not a good idea to be blindsided on a trial. Number two, the opposing counsel will push that envelope and say to the judge, I need you to compel the testimony of whatever question it asks. And then they'll point to an attorney, says, counsel, what is your position on this? If your attorney did not know in advance, most likely your attorney would ask for a 5-minute recess to talk to you about it, to discuss specifically what are the reasons why you do not want to talk about that testimony. But the judge can compel you to testify if it's something that is relevant to the case and material. You still refuse to testify, judge has a lot of options. They can hold you in contempt of court. They can have negative inferences. They can go ahead and impose sanctions upon you, upon your case. It's just not helpful to do that. So if there's something you do not want to talk about in trial, let your attorney know in advance, and then your attorney can address it in advance to the extent possible. You may have witnesses that are coming to your case on your behalf. They have been subpoenaed or voluntarily have been there. It's important that you do not discuss the case with your witnesses. Your attorney should be the only one discussing the case with your witnesses. The only thing you can talk about them is how to get to the courthouse and at what time to be there. Because anything you discuss with potential witnesses is not privileged information. It's not confidential. So anything you say to them, they can ask the witnesses, hey, you spoke with Mr. Smith, 2 days ago. Yes. So what do you guys talk about? He can ask that question. Because anything that you said is admission by party opponent. Okay, admission against interest. So other than saying how to get to the courthouse, just don't talk to them before the case. And your attorney should be the only one. If they have any questions, refer them to your attorney to discuss any aspects of the testimony. Conduct, courtroom conduct and expectations. Dress code, our attorneys will dress in a suit. It's a standard, professional appearance that we have for the courtroom. But for you, think of it as going as a business meeting. Let's say professional is important. Business casual, anything not below business casual. Just go in a suit, go in a jacket. You don't have to wear a tie. Ladies, a nice dress, whatever, or So just think about going to a business meeting, because this is really the most important thing going on in your day at that moment. It's a trial. So, but first impressions count, whether it's for the jury or the judge. We're being judged there, all of us. So how you present yourself is important. So keep that in mind. Cell phones, silence them, or in some cases, the court requires the phones to be completely off. They have a sign outside. We got to respect the court's proceedings. So if they say turn the phones off, we'll turn them off. There will be breaks throughout the course of the trial, depending how long the trial is. There will be breaks. 5-minute breaks, 15-minute breaks, depending on the case may be. If it takes more than a day, during the day, it will be a lunch break. So you'll have a time to go to the restroom and, stretch your legs, make a phone call if you have to during the break. So you'll have that opportunity to do that. In some cases, it might be a long day. Bring water, snacks. And there's snack vending machines in the courtroom. Those little details are important. Try to get there early so you don't have to deal with traffic or deal with, delays in parking. And also you want to make that experience as least stressful as possible. It's already stressful. So planning ahead is very important in this case. Your attitude, your body language, all that is shown. So to a degree, just remember you're being seen, you're being judged. So just try to get through it as best you can, and your attorney will be helpful to you. And sometimes bring a paralegal to also assist you. One thing, sometimes attorneys are listening to the testimony of the witness. If they have in a direct examination of the opposing side's witness, we have to listen to every single word and to the question and the answer, and specifically to the question, because depending on what the question is, we might have to object. We also have to look at the documents they're going to produce. Most likely, we've seen every single document. We have agreed that they're admissible. Sometimes they're not. But if you have something very important to share with your attorney, you can write a note and pass it along, but don't make it a practice to keep writing and sending things to your attorney. I'll tell you why. Because by doing that, you're distracting your attorney from paying attention to a testimony of the opposing party. And you might miss an objection. It's a matter of seconds. And if it's not objected, it's admitted. So you have to I hate to call it a game, but it's a listening game that we have to actively listen. And if it's something critical or important, yes. If it's something that can wait, just write it down, wait during the break. And I see that because sometimes I'm taking depositions, they're via Zoom. Sometimes the clients are trying to be helpful during a hearing. They send me text messages. It's important. It's impossible to pay attention to two people at once. So let your attorney do his job or her job, focusing on the trial. During the break, address whatever issues that you might want to talk about. There'll be a lot of legal maneuvers and legal procedures that are going to be completely out of your head. That's understandable. We know what we're doing. But it's important to allow the attorney to be in the driver's seat this time and just let him drive. We'll let her drive, okay, without disruptions or without interruptions, because that is important to your case. As I mentioned earlier today, at the beginning of the podcast, settlement is always an option. If you feel the case is not going your way, which could happen, something that you said or something the other side said, or something common that the judge might have made based on some of the questions, you can always try to settle the case before a verdict is rendered. There's nothing preventing that. We can ask if it's a possibility for settlement. We can ask the judge, can we have half an hour break? It's a possibility we might settle this case. We want to have a conversation with opposing counsel. Can we get a room in the courthouse so we can talk about it? They'll do it. They'll give it to you. So you got to be nimble and flexible. I think it's the same word. You have to have the flexibility to adapt to new circumstances that occur at trial. So you always have that in your mind, have that open mind that if things are not going your way, settlement might be an option. Likewise, if things are going your way, the other side might say, you know what, we want to settle this. But the reality is this. We can have the best possible case, present the best evidence. We do not know what the judge is going to do, what the jury is going to do. We do not know that. And in business cases, sometimes what happens is this. The judge looks at the evidence. Let's talk about bench trial here. Looks at the evidence. I said, thank you very much. I'll take it under advisement. What I like to do is for both sides to provide to me proposed orders. What that means is the judge is not going to make a decision at that case and that particular afternoon. You're not going to know what the outcome is, but he wants us, the attorneys, to present proposed orders based on what happened at the entire trial. So what we have to do is order the transcript of the trial and go back to the entire trial transcript and present a comprehensive order about why we should win this case, why the judge should rule in our favor. So in essence, it's trying the case again on paper and preparing that in the form of an order. And that could take an extra week. By the time we get a trial transcript, by the time we send it out, it can take another week. And by the time the judge rules on that, it might be another week. So just because you have a trial that day doesn't mean that you will know exactly what happened that day. With the exception of a jury trial, the jury will render the decision once all the evidence is sent to the jury room, and then the jury will render a verdict. You will know at the end of the trial, and a bench trial may not be the case. Let's talk about bench in this case. The judge rules in your favor. The other side has 15 days to file what's called a motion for reconsideration and to reconsider the verdict or the final judgment. And then the judge can agree or disagree to that. And then they have their 30 days to file an appeal on whatever grounds they feel are appropriate, and likewise on this side. So that what I'm telling you is that just because you have a final verdict does not mean that the case ends, because there are post-verdict motions that take place after that, and then you have an appeal that could take place or not. So if you see an opportunity for settlement, be open-minded to it, because if you have a settlement, as I mentioned before, you have closure. Anytime you can have closure and certainty in anything, especially in business litigation, is better than uncertainty of a verdict. Doesn't mean that you have to settle. Doesn't mean you have to agree to it. It's simply be open-minded to listen. If you feel that the terms offered to you are not good enough, that you'd rather see this play out all the way to trial and verdict, fine. Nothing wrong with that. But what I'm saying to you, the opportunity always is available to you if you want to. I think this is good for today. I do appreciate you listening to me. I appreciate this is episode 95, Business SOS. I'm very excited as we get close to episode 100. If you want to reach me, my email is rich, R-I-C-H, at richsierra.com. Again, it's rich at richsierra.com. If you want to call me, my number is 866-842-5202. Don't forget to check out my book on Amazon, Business SOS, 8 Common Legal Mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You could ask for your local bookstore as well. If you are listening to the show, I appreciate if you give me a review. Appreciate a 5-star review. Follow us, share it with your friends. And if you want to see the video of this podcast, we're available on youtube.com/@RichardSierra. We have a lot of videos there. We are close to 600 videos now. Very excited. And podcast getting over 16,000 subscribers. And this last week got over 50,000 views. I'm very proud of that as the YouTube channel continues to grow. Until next week, this is Rich Sierra. And my goal is to help you succeed.